Bell right, bell smart.
To learn more, log on to www.reready.org.
Will be heard by you and sanctioned by you. We ask this morning, as we deliberate on the matters touching the occupational health and safety, that you guide our thoughts, make them clear, and so that at the end of the day, you'll be pleased with all that we do. These and other mercies we ask in your holy and precious name, through Jesus Christ, our Lord. Amen.
Amen. Any apologies for absence?
Senator Skeffrey was away and he's coming back later today, so we apologize for his absence.
Yes. So that's only Senator Skeffrey. We move to the next item, which is really the welcome and opening remarks. Again, members, I welcome you all to this another sitting. We have been meeting like this for some time now. Today we are set to continue. I believe on the last occasion we were at part 6 of the bill. I believe that the ministry would have circulated a document indicating the new direction it intends to go, having regards to this discussions of last week. So members, I do not know if you have, well, you should be in receipt of this document, a 3-page document from the ministry. Substantially, I believe, from the ministries, and this is what should be guiding the conversation in regards to part 6. Members, do we have that document? So we will then proceed, ministry, to resume our deliberations at part 6, and we just ask that you lead. Mrs. Michael, Miss Michael, I gather that you will be leading today, so you may now proceed.
Good morning, members and colleagues.
For the record, I'll just ask that you introduce yourself.
I am Janita Smichael, Senior Legal Officer, the Ministry of Labor and Social Security. Apologies for Mrs. Bennett Campbell. She is unable to be here today. So on the last occasion, the ministry was asked to revisit part 6, and we have reviewed our policy and will be indicating our recommendations to you, which is outlined in the documents. So the first thing is we are recommending that the heading of part 4 be amended to reflect the prohibition of reprisal by the person conducting a business or undertaking. Sorry, part 6.
Members, we would seek an agreement on that. I do not know if there are any comments from committee members or from the different legal teams.
Comment on paragraph 1, Chair?
Well, it's the heading of part 6. Yes. Okay, so, yes, very well. So that's an agreement. Very well. You may proceed. Paragraph 2.
We're proposing that clauses 103 through to 107 are amended to reflect the following policy. A, that a person conducting a business or undertaking or a person acting on behalf of a person conducting a business or undertaking is prohibited from 1, dismissing or threatening to dismiss a worker or otherwise terminating or threatening to terminate the contract of employment or engagement, suspending or otherwise disciplining a worker or threatening to suspend or otherwise discipline a worker, imposing any penalty upon a worker, intimidating, coercing, harassing, or victimizing a worker, or otherwise adversely affecting the worker in respect of his employment, profession, or office, including employment opportunities or job security, because the worker has acted in compliance with or sought to enforce or give evidence in a proceeding under this Act, regulations, order, or a code of practice made under this Act. You'll recall that, well, the bill had made provisions for prohibition of discriminatory conduct, and we had set out meanings of discriminatory conduct and the meaning for prohibitory reason, which generated some discussions. And it is in light of that we had proposed a change where we had proposed to use the term occupational detriment, but we were asked to look again at the CARICOM model, which we did, and we also considered Canada and proposed this amendment.
Members?
Chairman, let me ask something. Do you know, are you aware if the place was painted over the weekend? I'm picking up a scent of some sort, and I consider it an occupational hazard.
Well, Member Gill,
I'm very sensitive to these.
No, and another member of this committee did bring it to my attention that the scent of paint is affecting her adversely. But I'm just being told that yes, painting did take place over the weekend. So, by virtue of what is being discussed here,
I don't know why. We plan to build a new parliament.
Yes. Yes. But if it becomes unbearable, then I guess as a committee we just have to take a decision.
Any member of the staff who feels it is at a level that is unbearable, and by the staff I mean the technocrats and the lawyers, because if it is so, then such individual probably could be excused. Yeah.
Well, I guess if anybody is so impacted, you could indicate. I know, Sergeant, you indicate a problem earlier. But if it is that you are unable to, you will be excused from these proceedings. So may we proceed now, members? The paragraph 2 in this document, the proposal now being contemplated by the ministry. I know on the last occasion, one of the concerns would have been the fact that this bill, as was indicated, had a regime for itself when we were saying that another regime was already established in another legislation, and some of what was discussed in the bill would have been the same sort of matters in the other legislation, and there was no need to introduce a different regime under this bill. So I don't know if it would have members captured the concerns and the discussions of last week.
Chair, at 2A, 2 use the word otherwise discipline. 2A, 5 use the term otherwise adversely affecting. But I'm not sure if either capture something that I've heard policemen complain of, and I've known of workers in other areas complain of, something called transfer. Transfer may not be deemed disciplinary action, otherwise disciplinary, or otherwise adversely affecting. And is there any thought about how we treat somebody saying, well, I'm going to send Leslie to Westmoreland, and I have the right because his job says that he's transferable. It could happen to firemen, for example. It could happen to correctional officers. And it could happen in the private sector. So I'm just wondering what is the thought, if any?
We considered.
Member Gail, Member Brown, sorry. Is it that you're, making a recommendation that we look at and express wording to include the transfer if it is that it is done as a means of disciplining?
This is why I wanted to hear their thought first, and then I'll tell you where I want to go with it.
Minister?
Thank you, Minister. When we considered the matter, the issue of transfer was discussed, and we considered that depending on the nature of the transfer, so if it is that it is because of a safety and health complaint, for example, or a matter arising in respect of safety and health, that the person is transferred, then it could be construed as a penalty, particularly if it is to the person's detriment, which is why we thought about if it is that the PCBU is imposing a penalty. But in case it is not a penalty in the way that the transfer is effected, we also consider that it could adversely affect that worker who is transferred. To use your example, if a person is transferred to Westmoreland just because of the matter at hand, the person could be adversely affected, and then that could give rise to a complaint under the bill.
So you're saying only the person feels adversely impacted. That is to say, I'm away from my family when the other job where I was, as in Kingston, I've been transferred to Portland, and I'm away from my family. Is that adverse sufficient?
Member, to my mind, a mere feeling would not suffice. It would have to be, it all depends on the circumstances that gives rise to the transfer. And if, because of whatever would have been happening at the time, the PCBU thought that in order to, I don't want to use the word discipline, but to address the situation or that concern, they are going to transfer the person.
In which case, Chairman, I'd recommend that transfer be put in the thing, and that it must be for the PCBU to prove that the transfer is not connected to the complaint. So where somebody has been complained and is then transferred, then it should be, that person should be protected. No employer is going to tell you that the reason them transferring you is because you made a complaint. It may be easier that if they transfer you because you're pregnant, because you cannot see that. But because of so much subjective factors, I want to protect people being transferred, because that's a method of getting rid of troublemakers.
Yes. Any comments from the legal teams? Members, you have heard the submission made by Member Brown. Do we agree to this, Ministry? You have heard the proposal from Member Brown. Do you have any comment on that?
Minister, I believe we will have to review that particular issue and to see how it is that it would, it can be applied. Because if we just put in a mere transfer, then we would be opening up ourselves to persons who do not wish to be transferred when it is already a part of their contract that they could be transferred to do work that, and they do not want to go to Westmoreland, for example. Then it would open up a argument for them to say that they have been subjected to that transfer as a result.
Chairman, it's not just transfer. It is transfer having made a complaint, a safety, so that's is attached to it. So if somebody having made a complaint is transfer, and I don't mind you putting it at 2A3, imposing any penalty, including transfer, upon a worker, because it's connected to the complaint.
Minister?
Yes, sir. We will consider it.
Very well.
Sorry, Chairman, but I'm not sure I like the formulation. I don't have a problem with putting in a transfer, but I wouldn't want it twinned with the word penalty. Because generally a transfer is not a penalty. But I understand that in the context, it could be seen as a penalty, but I would prefer not to twin it in 3.
I don't insist that it be between.
So meaning once it's included in the listing.
Find a way to protect the
yeah,
worker.
once it's included in the listing, we wouldn't object.
Mr. Simmons, you wanted to? Yes.
Well, I agree, Mr. Chairman, that it would have to be taken under some consideration, because generally speaking, once you're employed somewhere, you are employed to do what the employer asks you to do, plain and simple. So if the transfer is not to your detriment, meaning in terms of being demoted or affecting your salary, I don't think in law you can strictly speaking complain for that alone. So it's something that definitely has to be considered further.
I thought the context was that it is as a direct result of the person having made a complaint. So it would be fine. So the issue is, it's the same kind of issue you have in the Protected Disclosures Act, where you're not supposed to, you should not be affected in any way because you have made a complaint. So I think this is a context within which you're going to have the listing in 2A. And that's why we wouldn't object once the parameters are clear, which were outlined or reinforced by Senator Brown.
Could it be included in 5? Otherwise adversely affecting the worker in respect of his employment, profession, or office, including employment opportunities or job security. Whether or not it could be included in 5. I can understand what Senator Brown is suggesting. The only thing is that transfer standing on its own would not be viewed as punitive, and the others in 1, 2, and 3 and 4 appears punitive in nature. Transfer is a correlation to the engagement of employment. That's a natural course. But in the case that Senator Brown is suggested, it may be viewed as a result of the worker raising an alarm. So I don't know if we could put it in 5, as a possibility.
Any comment, Mrs. Seeley Brown? Yes.
Then we would
Very
determine.
well. All right, members, so we agree to include transfer as a consequence of a complaint that has adversely affected the worker in this paragraph. It's for the drafters. You will make the determination as to where it goes.
Just
Yes.
the final thing in 2, in 2A. It says, because the workers complain, with or sought to enforce or give evidence in a proceeding under this act, regulations, order, or a code of practice. No, we're elevating a code of practice to the level of regulations, orders, which strike me that they need parliamentary approval, usually, special regulations. But the code at 214 in the legislation doesn't require, it appears to me, parliamentary approval. And so, and it can be varied and changed at any time. So I'm wondering whether or not either 214 we need to fix the question who approves code of practice.
Provides a mechanism, though.
No,
it's at 2 A, B, and C.
it says
If you may, we were going to actually suggest some changes to
Yes.
214 because right now it is too vague. It needs more explanation in this code, like what was supposed to be addressed in the code. Is it one code or several codes? I say that because we have found an issue in another piece of legislation. Depending on how you phrase it, you hear that it's really supposed to just be one code, whereas there are times when the intention is to have several different codes. So there were a number of things we were going to ask here. We're also going to ask if you wanted the code to have teeth and be more like regulations. And then you would have had to then put you'd have to do further adjustments. So we were going to make those proposals at 214. But I would ask if perhaps you could wait because, for instance, you notice that it's come up here, and I think the way the bill is now evolving and how the ministry is reconsidering some of the provisions, it may better inform when we reach the 214 how you would decide on treating with the issues.
Chairman, I'll wait.
Very well.
But I at least signal now.
Yes.
That there's an issue.
So. Ministry, 2B.
If the worker is a worker, under Section 2 of the Labor Relations and Industrial Disputes Act, and the action complained of constitutes an industrial dispute under Section 2 of the legislation, the industrial dispute is to be referred to the minister in accordance with the provisions of the Labor Relations and Industrial Disputes Act. And the minister is to act in accordance with the provisions of the Labor Relations and Industrial Disputes Act. The Industrial Disputes Tribunal may make rules to expedite proceedings relating to industrial disputes emanating from this part. So at present, what obtains in the bill is that you would have the OSH division of the tribunal, and once it is an OSH matter, it is, and the intent was that the matter should go before that tribunal. However, based on concerns raised, we have revisited, and what we have done is to extract the section that has to treat with employees, so the employer-employee relationship, where the person is proved to be a worker, where the minister is satisfied that the aggrieved person is a worker under the LRIDA, and as you will recall, the LRIDA sets out what is an industrial dispute. If the dispute is one of those elements under the LRIDA, then we are now proposing that the mechanism to be invoked would be that of the LRIDA. Okay, the Labor Relations and Industrial Disputes, it sets out how the workers redress to where there is complaint of an industrial dispute. So termination, suspension, breach of rights and privileges of the worker, so it's the employer-employee relationship. Conditions of work. The labor relations, the LRIDA says if the person is a worker and the dispute is in relation to any of those, an industrial dispute, then ultimately the matter would be ventilated at the IDT, at the tribunal.
It won't fall under 2, so why are we even saying B? It won't fall under the circumstances we've listed under 2A. So I'm just querying why do we need B then? Because it's not an industrial dispute, because you've now tagged on the fact that the person would have acted in compliance with our sought to enforce or give evidence in proceedings under this act. So I'm just wondering now, why do we need to say, isn't it clear that if it is an industrial dispute, it would be dealt with under the LRIDA? Or am I missing something?
Because of clause 7. Because of clause 7, which define workers broadly, very broadly.
But I think she's making a different point. Yes.
To me, it's used in a particular context in 2A. So it's not an industrial dispute.
Are you saying that 2A does not highlight an industrial dispute?
That's what I'm thinking. It's because of the way it's now crafted and you have linked it to non-compliance with this act. I'm not understanding why we even have to say.
We just should do a subsequential amendment to the LRIDA and just incorporate section 7 under the definition of worker.
Still not following.
I think what Mrs. Seeley Brown is putting forward is that as listed under 2A, as we now have it, it does not constitute an industrial dispute, not under the LRIDA. So why then do we have 2B?
Chairman, what I understand is
yes,
that the LRID as it stands now have a certain regime for reference of disputes, and it has a definition of industrial disputes. The intention of the OSH Act will be to add to disputes matters arising from the USH. And that would require a consequential amendment to the LRID if you can fit it in. But because the LRID treats worker, the definition of worker, in a very restricted manner now, and it's different from clause 7 here, how do you capture those non-employee employer relationships?
I think C of this document.
I know that's where they're going eventually. That's where they're leading to in this document. I understand. But that explains the concern Mrs. Celia Brown had earlier.
Are you now comfortable, Mrs. Celia Brown? You're a little. Okay, very well. All right, fine.
But Chair,
yes,
it does not rule out a submission for a consequential amendment to the LRIDA to incorporate what we are encouraging here, what we are reviewing.
Yes.
Because we have to bear in mind that when
and when you say amendment, in terms of what?
The definition
of worker.
And also how we are trying to incorporate what would be in 2A, because it never took into consideration when that piece of, when the LRIDA was being developed, or any amendment, that we're going to review this to the extent. Never took that into consideration. So maybe it's something that we ought to consider for future.
I'm sure that preliminary work has started. I know consultations have started, Member Gale. Yes, I know consultations have started to see whether any amendment is needed where the LRID is concerned. So I know we are here dealing with OSH issues, but I will say that by virtue of certain happenings, which you are very well aware, consultations have begun to see whether an amendment is needed to the LRIDA. But in respect of clause of point 2b, paragraph 2b, yes, I know that very well. Yes, in respect of clause 2b, that is what we are seeking, whether the members are agreeable to the proposal that is now being put forward. Yes.
So we're grappling with clause 7 and the definition we have there.
Clause 7 of worker?
The meaning of
yes.
And I somehow see an internal conflict if we then introduce, by virtue of B,
yes,
a definition which is not the definition. So the bill is going to have now be saddled with two definitions.
No, it's really one. I think the definition of work under the LRIDA is narrower than the definition of worker under this bill. And what 2B is seeking to do is to capture a situation where the worker falls within the definition.
So we have two situations operating under the one bill, and and hence I say it is an internal conflict.
Yes.
It should be consistent. We should have just one meaning.
Yes.
For the worker.
Yes, and
no, you don't have one meaning, because it says the worker is as defined under the
LRIDA. Yes. So what I will agree, Member Campbell, is that worker under this bill is broader than worker as defined under the LRIDA.
Yes.
Under that is yes.
So my position would be to once it is going to deal with a worker, under these provisions, that it should be confined to the broad definition as set out in Section 7.
Yes, but I think what is been put forward here is a dual system. If you are a worker that falls within the meaning of the term worker under the LRIDA, a mechanism is provided for under this bill consistent with the mechanism as established under the LRIDA. If you are a worker that is outside of the definition of the term worker as provided for under the LRIDA, that is where 2C is now coming in. So I do not know if you have looked at 2C on the document that the ministry has given to you, but I get what you're saying, that we have to look to a standardization of the term, yes, of a worker.
You seeking the committee's vote on it, huh? Because we certainly...
For that right away.
We can
offer that right away, Chair.
I did say consultations are ongoing. Yes, certainly, yes. Yes, Ms. Michael.
I just wanted to point out that the LRIDA has two definitions for industrial disputes. Those who are part of a collective agreement, bargaining unit, and those for the non-unionized. Now, you will understand that the definition, there's a slight difference for those who would be under the collective regime versus those under the non-unionized regime. Because, for example, the non-unionized speaks about the physical condition in which the worker is required to work, the termination or suspension of employment, any matter affecting the rights and duties of any employer or organization representing employers, or any workers or organization representing workers. While when you look at the collective regime, it speaks about terms and conditions of employment or physical conditions in which any worker are required to work, engagement or non-engagement, or termination or suspension of employment of one or more workers, allocation of work as between workers or a group of workers, any matter affecting the privileges, rights, and duties of any employer, and so forth. Now, there is some difference. Now, if you're a non-unionized worker and a disciplinary action occurs, if you do not fall within, and that dispute is one that is within the collective regime, then you would not be covered despite the fact that you're an employee. So, which is why we have to have that you are a worker and that there's an industrial dispute existing. Now, what happened is that we have to treat with that to offer that protection for all the employees, because you would find that some employees would have greater protection than some, which is why we carved out this definition. So when you look at dismissing, that's a termination under the LRIDA, which would capture the worker. And the disciplinary situation, any disciplinary action that would give rise to the dispute. But you could find situations where even though you are a worker, you are not covered under the LRID, and that is what we were trying to cover.
I understand that. Just to be clear, you're saying under the current LRID, there are already two different standards of workers in terms of reference and what they can take to the Industrial Dispute Tribunal. We are creating a third with this for all of those who are not now covered by the LRIDA. So those subcontractors, etc., are to be covered under the ASH Act with a certain regime for reference of their dispute, ASH dispute that is, to the tribunal. Am I correct? That's what, sir? Good. And Chairman, I agree fully with that. There's no conflict there. The issue that I think the ministry has to resolve is under those first two, under the current LRIDA, reference is made by the minister, having had the matter referred, first try to settle locally, then refer to the conciliators at the ministry, and a failure of that, the minister has certain powers, whether can refer it on his or her own, or joint requests from the parties, or essential service, which, okay. And we now want to, I'm not clear what we're adding here for these non-LRIDA workers. What is the method? I've read the thing, and it says the minister is required to. The minister is required to. Is that the minister, is it really the minister shall refer, or the minister is going to retain the discretion as to whether or not he or she makes the reference? Which is the case now with the non-essential service LRIDA and the non-collective agreement, not collective agreement, non-joint requests for reference. So I'm just trying to get a sense of the regime that would get the minister to make this reference. So whether that regime now include going through conciliation, and whether the minister retains a discretion not to refer it.
Before you come in, Mr. Michael, Member Brown, I understand you are now talking about the procedure as outlined in points D to H. Yes, so I will invite you, Ms. Michael, to just walk us through the procedures outlined here, and then we get to Member Brown's.
So we will pick up at C, Minister.
Yes.
So if the worker does not fall within the definition of worker under the LRIDA, or the action complained of does not constitute an industrial dispute under Section 2 of the LRIDA, then the complaint should be addressed as follows. A worker who is alleging a breach, well, we're using 103 now because that's what is currently under the bill, but you'd understand that there would be some adjustment. So a worker who is alleging a breach of Section 103 or his representative is required to first endeavor to settle his or her complaint with the person conducting the business or undertaking, or his representative in accordance with the agreed procedure or the default procedure prescribed in regulations. So what we're contemplating here is a local level dialogue, that you would have some discourse between the aggrieved person. Oh, thanks. Oh, I think you may have, oh, that's all right. Yes. So we're contemplating here that there would be some dialogue between the PCBU and the worker, it's with the effort to settle in the dispute before it is elevated. And it is anticipated that there would be some procedure to guide what it is that, what are the actions or how the talk should go before the matter is elevated, which is why we have an agreed procedure. The PCBU and the worker would have some agreement as to how it is that they would seek to ventilate the complaint. And if that fails, if there is none, then it is intended that there would be a procedure that would be prescribed in law, which currently exists in the LRIDA, which is the implied procedure under Section 6. So if that fails, we're at E. And pardon me, at D, I think we use the word alleging a breach. It is actually alleging a complaint. At E, If the complaint is not settled after reasonable efforts have been made to resolve same, that's a complaint, in accordance with D above, the aggrieved worker or his representative or the person conducting the business or undertaking or his representative may request in writing that the minister with responsibility for labor assist in settling the complaint by means of conciliation. And it is proposed, it is recommended that this request should be made to the ministry within 12 months of the date of the occurrence of the action or complaint. F, if the...
Yes, Member Brown.
Before she get to F.
Yes.
The 12 months. Why not just amend the LRID? I think it's 11B or something like that, where it says disciplinary action must be reported within a year to go there. We could just add OSHA issue, because so you don't have to be putting in the law, this law at 12 months, and we have it in the LRID. So, it's just a form. It's just whether I want to be stating it twice in the laws. That I'm told by the minister that you're going to bring a consolidated labor code with all of these laws at some point. I don't know. Did I get it wrong?
I don't recall that conversation. Yes.
But Chairman, did I read you wrong earlier? This is setting out a procedure. I don't think right now you're asking the committee to settle on what are the amendments to the LRIDA.
Oh, absolutely not.
Right, so it may be accommodated depending on when we go through and when the committee takes their decision. After that, then there would be no some amount of assessment as to how best to place all of these amendments.
Yes. Yes, Ms. Michael.
The challenge, Member Brown, with amending the LRIDA for the 12 to put everybody under OSHA is that it would not fix the issue that we have. Remember, it's the extended definition, the wide definition of worker that we're talking about here. So we're talking about limitation, well, the time frame within which any of the aggrieved workers under this
Accepted.
Yes. Yeah, proceed.
F, if the minister is not satisfied that such reasonable efforts have been made to settle the complaint, the minister may direct the parties in writing to adhere to such procedure in D within a specified period. So this is where the minister is not satisfied that the matter has been properly or completely ventilated at the local level.
Member Gill?
My concern with F is the word may direct. So may with that term direct is as if you may instruct. And what would be the sense in giving that directive that somebody may not accept? And then you have to deal with G. I was just trying to understand why you want to insert F in this. What was the reason? Let's pause for the blue.
Welcome, Member Clark. I guess that's for you. Yes.
I'm just seeking
Is it that
some
you're
clarity.
saying that you are not convinced that F is needed?
I don't know if it's, I don't know if it's needed. I don't know what it is seeking to do.
Okay. Mrs. Silva?
I just think it's unnecessary burden on the minister and the ministry. If the complaint is not settled between the parties, you take it straight to the whoever.
Member Brown?
No, it's the same. I think it's a provision that is in the LRIDA, and they're copying it to the OSHA side of the LRIDA. When ministers want to play around, it's a tool that they can say, go back and talk. But usually it's a reference to the IDT at some point thereafter.
Mm-hmm. Oh, well. Yes, Mrs. Michael. Mm-hmm.
So, Section 11A of the LRIDA mandates the minister to satisfy herself that all attempts were made to resolve the dispute. And this is a requirement that she would have to ensure. She must be satisfied, Minister, that that the parties had the discussion at local level, but the dispute remains unresolved. If you would recall the case of, I think it's a village resort, this is a matter that came up. And the ministry, the court had found that the minister had not properly ventilated all the measures in ascertaining that the dispute was addressed, or the parties had sought to ventilate that dispute before actually elevating the matter further. So this is one, particularly as it has far-reaching effect for workers under the LRID, that for consistency, we would have to keep in the provisions.
Very well.
Just for the record, I think it's Western is East. I think it's Western is East, not Village Resort.
But just for clarity, because this says, whilst I can appreciate and understand what is contained in terms of the procedure in the LRIDA, this is seeking to direct the parties in writing to adhere to such procedures as outlined in A, which is not entirely the same thing.
I think A there should be D.
No, it
A
was
should be
sorry.
A should be D.
D. Sorry, D.
That's a clerical error.
Okay.
I'm sorry, Minister, wherever A appears, it should be D. I'm sorry, members.
So, Member Brown, having read F correctly, are you still, and having heard these submissions?
I support it because it is part of the existing legislation.
Very well.
So forth.
So may we proceed? E? G?
The minister is required to refer the complaint to the tribunal for settlement on his own initiative, where he is satisfied that reasonable efforts were made without success to settle the complaint by such means as were available to the parties, or if in his opinion all the circumstances surrounding the complaint constitute such an urgent or exceptional situation that it would be expedient to do so.
Any comment, members?
Chairman, I just a little conflicted by the document. Is it a policy position? Is it draft? It's not draft,
policy.
it's policy.
Yeah, it's policy. He knows.
Yeah. And therefore, I raised that. So, is it the intention, because I raised it earlier, is it the intention that the minister shall make the reference, or the minister may make the reference? Because that needs to be clear.
Is required, seems. Yes. Yes. I think is required there is to be read to mean shall, but yes.
I hear you, Minister, and I accept the chairman. But I see the discomfort on the face of the technocrats from the Means yes, there is. Don't.
I see you're an expert
In other
at
words,
reading facial expressions.
this one is touchy, and they don't want to be the first to pronounce on it. I have to read body language, Ms. Jules. So,
Yes.
So, in other words, because this is a departure from the normal thing. I mean, when it came to us first, it was the individual could go down to the tribunal in Samshab Square era and make a complaint. We're shifting from that. So now the individual has to go through the Ministry of Labour, whether down in Mobile or in Kingston or wherever, go through conciliation, and then conciliators make a recommendation to the minister. The current situation, which I don't like, is that the minister can say, I am not referring it to the tribunal. Now we're saying it is to be read that the minister shall make that reference. I'm happy for that, I must tell you. But I don't know if that's where you're going. But if I hear the chairman and minister is saying that's where they're going, I'm cool with that. I'll vote for that.
Yes.
Chair, to my mind, we're creating a new procedure to do it, right? So follow me through. Not because we have something already means that we need to adopt it every time. It depends, in my mind, on the circumstances.
Yes. Mm-hmm.
I remember, I think, when we did the sexual harassment bill, the procedure was that you had to just prove, a person who's making a complaint had to just prove that they have exhausted all of their internal remedies to the tribunal, which to me, in a case like this, is a much simpler process than having the minister involved and having to deal with all these technical aspects of it. So I understand what happened in that case because you had that particular procedure in the Labor Industrial Disputes Act. But I don't think it means that we should just slavishly follow it. And as Member Brown was saying, and all of these little nuances that we're creating about going to the minutes and he must be satisfied. All we need to say is that the person makes the complaint to their employer, and if they're not satisfied, once they have shown or proven to the tribunal that they have exhausted all of these internal mechanisms to make a complaint and they have not been addressed, then the tribunal hears the matter and end it there.
Mr. Chair, if I
Yes,
may.
Mr. Simmons, yes.
May I support the Solicitor General's comment earlier that we probably should, I believe she said, allow the ministry to go through and then we look back at what they have proposed, because I can tell you from my position right now, I'm actually entirely confused by what is taking place. I think we need to bear in mind that the IDT does have a set regime to deal with industrial disputes. And what we're trying to do is to fit OSH matters into the IDT. From my perspective, the IDT is called the IDT for a particular reason. Industrial Disputes Tribunal. So whatever we do under the OSH under the OSH Act, in my view, has to fit in with what is currently prevails for the IDT. So I'm not understanding the difference between the procedure right now under B and C to F or C to G, because it sounds more or less the same thing to me. And I don't know why it is you would have in one section the definition under the LRDA, and then another part definition if you don't fall within the definition under the LRDA, but yet it's still the same procedure to go to the IDT. And that to me is kind of confusing. So I do think we need to just, after we leave here, look back at it and see what is really going on. But my suspicion is that you're going to have a difficulty fitting the OSH issues under the LRIDA.
Member Cuthbert?
I just wanted to, from what Mr. Simmons said, does that mean then you would possibly like to see E, F, and G take it removed?
I think he's suggesting that a tribunal separate and apart from the IDT be established.
I actually do think that's the best route to take.
Chairman, let me just clarify something.
Yes.
one problem. I'm not on the sexual harassment committee, but I think Mrs. Celia Brown attends. Could she tell us whether or not the intention is to take the sexual harassment complaint to an independent tribunal, not to the, but the protective disclosure goes to the IDT.
But if
Am
I
I
may,
correct?
I do believe though under that act,
Yes.
the protected disclosure actually does define an industrial dispute, which is why it can go to the IDT.
And there's nothing to prevent ash matters from being defined as an industrial dispute. But I'm worried about the multiplicity of tribunals. And where I sit in the Senate, Health Tribunal, I don't think it functions one day. Then you have Consumer Tribunal. And maybe we should ask one of the researchers from who serve in the parliament now, how many different tribunals we have. We have pension tribunal, we have so many tribunals. Almost none of them working, except the very few. So maybe someone we should look at to see, in terms of policy, do we want to have a multiplicity, every legislation of its own tribunal, or we set up a system of tribunals that can deal with issues. So, in other words, I don't know how many tribunals we have, but I'm not happy to go create another one for Ash.
Sorry.
Sorry, I was just looking at the Protected Disclosures Act. It actually amended the LRID to recognize the matters under. So the definition of industrial dispute in the LRID was actually amended. It's not that it was put in protected disclosures, but there are different mechanisms. There are different ways that it can be done. And in fact, when at the early stages of sexual harassment, when there was a discussion of having a new division of the IDT and looking at how it could be done, just to, in a way, respond to Member Brown's comments about the multiplicity of all these tribunals, it has come up for discussion because I've been there in some of those discussions, and especially because of this rationalization of the public sector, it has come up for discussion. And in fact, this was one of the reasons for years now. In fact, when we were doing sexual harassment, they were trying to see if it could work with the IDT, but then policy has gone in a different direction again for a number of reasons. But for instance, with the data protection, the intention is to use the existing ATI appeal tribunal, but of course expand it, so it wouldn't probably be called that. Again, trying to see how you can consolidate where necessary and be, I don't want to say frugal, but to see how you can best utilize your resources, including not just the financial, but even the human resources, because we have also seen an issue in terms of trying to get tribunal members to serve. So if you really do have a consolidation, it assists there. So there have been those discussions. It's not that the government and successive governments have discussed these things. And those discussions do continue. But a lot of times you do have persons who are fighting for some amount of control over their area and their subject matter. So it doesn't always work well in the end when you want to consolidate.
So, Chair, so for Senator Brown, I'm on the committee dealing with the sexual harassment. And there's a special tribunal that is being sought for this. Notwithstanding that I'm seeing some expansive issues that is being suggested to go before that tribunal that is out of the remit of the objectives of that piece of legislation, but that is for debate there. I can understand what is being sought here in terms of E, F, and G, where The tribunal, as it is now, has a capacity issue, especially with the amendment that gave rise to the non-unionized having those plethora of issues going there. What E, F, and G is seeking to do is procedurally and progressively to ensure that all efforts would have been made to try and settle the issue before the minister is required. Because this is strong now, you know. This is saying that if all attempts have been made, which is clear in E and F, that the minister shall, if there is no agreement, the minister shall refer the matter to the IDT. Now, I'm in support of E and F. And all those areas that would spend some time at the ministry to try and settle the issue. Right? So my suggestion is to retain those areas.
Very well. Member Brownberg.
Mr. Chairman, I would have had no problem with it not going through the minister, as long as there is a procedure that is clear that all efforts at the local level would have been exhausted. But if we are to retain the intervention of the minister, like others have been saying, I want to make sure that once it is the condition is satisfied, that local level has been exhausted, that the minister shall. And I think that that is extremely important. Also, at F, the minister having satisfied herself that all reasonable efforts have been made to settle the complaint. I know that it says that the minister may direct the parties in writing to adhere to such procedure as outlined in D within a specified period, and that specified period is not named. I am hoping that somewhere there is going to be a sense that there's no need for delay from the minister, and that the matter is sent to the tribunal forthwith. And I think that that is important, especially, in this day and age. If the minister said, okay, go back, make sure that you exhaust all avenues, all the procedures that are available to you, and the minister is then satisfied that having done that there is still no resolution, one would expect that that specified period is as short as it needs to be.
Mrs. Schmeichel?
Minister, I just wanted to say that the bill as it is, actually, the intent was for all matters dealing with occupational safety and health was to have gone to the OSH division of the tribunal. But we were told that we are to come up with a simplified process, taking into consideration what already obtains as it relates to to industrial dispute matters that already goes there. So this is an effort to come up with that simplified effort, having regard that already we have an existing mechanism for workers under the LRIDA to be elevated to the tribunal for their dispute to be heard. We could, in order, as it relates to the persons who fall within that wider definition of worker, the independent contractors, for example, we could not have had a totally different regime for those persons. Everybody would have to have come under the similar standard. And so this is our response in seeking to unify the matters.
Yes.
I just want to say I appreciate the approach, and I it has my support. While we copy the 12 months, for example, I just wonder in my head, it kind of bothered me. I just kind of come back to it. I'm working in a building that is freshly painted. And I have a right 12 months, 11 months after today to report it.
It says within, so I don't know if that helps.
I know.
Yes.
But
So
a report 11 months time
yes.
is still a report about the 3rd of February encounter. And are we setting up ourselves to be ridiculed by saying, if it's a health and safety thing, why give so long?
Yes.
I'm not knocking the approach. It just strikes me that we're subject to attack. In other words, we're saying you can prolong this.
Yes.
Unsafe when I'm continuing to work, Mr. Mann, with the electrical thing exposed for 12. Yes. I know you can't say I waive my right to complain, but the reality is, does this kind of tone down the pressure that is needed to get these things fixed? I don't think that's the intention, while protecting people's right to make complaints. But it sounds in conflict to me.
Member Brown, I hear the point you're making, but what is clear under this proposed regime is that it is not just the PCBU who has a right to make a complaint. It is the worker. And within 12 months, for me, is saying that you have the right 1 day, as well as it can go up to 12 months. So I think given what is involved and what is the nature of the breach, then it is to be treated accordingly. The need for standardization, because you couldn't say 30 days here, and then you have another regime that is saying 12 months, because already the LRIDA prescribes the 12 months within which to make the complaint. And if you are saying the workers under the LRIDA who falls within the OSH category, you are going to adopt that procedure, then I believe for tidiness, you have to standardize. But within, for me, Member Brown is sufficient, because within 12 months mean you can go from day one.
I know, it says after 12 months you can't come, that's really. But I'd want to urge that the public education that is going to flow from this, urge people to act promptly.
And it just assumes, Chair, that efforts within the 12 months would have been taken to resolve the issue, but I can understand Member Brown's concern, where someone representing a person conducting business may suggest that, oh, you have been sitting in the paint-infested building for 12 months or 11 months. So why are you complaining now? But I can say, the efforts would have been made to try and resolve the issue, including having the ministry intervening where those areas can instruct.
Member Brown, I could just add to the point that Member Brown made, that I think these are some of the things that we have to be mindful of for the public education part of it, because I believe that once workers understand what recourse they have, that they will use it, and if they understand the danger, that they will use it. So the important thing is to make sure that they understand what recourses they have, what recourse they have.
You proceed to H.
The minister is required to refer the complaint to the tribunal if all the parties to the complaint request in writing that the complaint is referred to the tribunal for settlement. So this is given the parties where, for example, there's the parties recognize that by themselves it would not, they would not be able to resolve the matter. Then through agreement, they could ask the minister to refer the matter to the tribunal.
So members, oh yes, it's required, yes. So members, the mechanism has put forward in D to H. Do we? Yes.
Just for clarity. So what we're saying is that the minister is required, once she is reasonably satisfied that all efforts at the local level have been exhausted, there's no resolution, to refer to the tribunal, or if
the ministry, at the local and then ministry.
At the local and then ministry. And as well as if both parties agree that they see no way by themselves of doing it.
Member Gill? Yes.
So this all of the parties to the complaint request. So suppose the employer don't wish to go to the tribunal and the worker says we want to go. Are we going to have should we have an agreement that both make the request or both are in agreement to go? No, I'm dealing with H.
I know, but the circumstance that you're referring to is what happens at G, where there's a disagreement. The worker don't want to go. The worker wants to go, the employer don't want to go. The minister can make that reference, or shall make that reference.
Because it means that
that's what they're saying. That's my understanding. Just it also has to be read with G. That is, if there's a disagreement between the parties, the minister shall refer it to the tribunal.
Yes. So members, we agree with this mechanism as set out. I just need an agreement from D to H. So agree? Yes. No, from D to H. They have agreed to the mechanism. Yes. I'm positive. So you may now proceed to I, as you have it on your document, Ministry.
In light of the proposed amendment to 10, that was discussed earlier, sorry, we would now recommend that section 105 is deleted.
Members?
Yes.
Do we agree, members?
Having taken 105 out, is there going to be a space for 105B in the legislation having to do with HIV and AIDS?
Ministry?
The ministry is considering this particular issue, and we are considering previous recommendation by the Solicitor General that this matter is best served if placed in a discreet manner in the bill. So we are still investigating or researching ways in which to fit it in.
No,
yes.
I just don't know, Chair, how discreet it could be and still be outlined in the bill.
Well,
That's what my understanding.
No, your understanding
That's what
based on
once
what
it's
you said?
included.
I hope that's what you mean there.
Oh, you're hoping. I can understand though,
Yes.
because there are those who would have raised it and have indicated that it's not contained anywhere in the bill. But it's just how it would be written, sir. Whilst not imposing information or highlighting information, personal information, but there is a way that they may want to include it in the legislation so that persons living with HIV is protected without the disclosure of information.
Yes.
As we well know, sorry, to you.
Yes, proceed, man.
As we well know, this bill has been held up because of the desire and the need to include something on HIV in it. That's part of the delay in this bill. We have obligations to the ILO to address this, to the International Labour Organization. The employers and the unions and the ministry have signed a national code on this issue. So there is agreement amongst the social partners for this. And for that reason, this bill should protect them. And so I understood discreet to be, it's going to be a clause in there that addressed that. I didn't understand discreet to mean that you're going to hide it. I leave it out.
Yes.
Right? So I just want to be clear. That's
No,
what
and
is intended.
I share that point, Member Brown. What I do recall the Sergeant says is that this provision could be accommodated elsewhere in the bill. So, you know, as long as it is in the bill, I don't know how you can say it's discreet. Yes, yes, yes.
Chair, the procedure for making a complaint in a case like this can't be like what we're suggesting here. The procedure
Yes.
for making a complaint in circumstances such as 105B can't be this procedure that we, so maybe we may have to do it, have us, you know, you understand?
Which is what the Sergeant was saying.
Separate mechanism.
That is the understanding.
Totally separate mechanism for you.
Yes, very well. Just even accept that query. Do we agree that 105 be deleted? Very well. J, Minister.
Clause 107 is to be deleted based on concerns raised by the committee. The committee had indicated that I think there is a view that we're limiting the rights of or activities of the unions. And so it is proposed that it is to be deleted. In addition, when we further review, we recognize that we may have been infringing on some rights that are already existing in the LRIDA, because Section 4 of the Labor Relations and Industrial Disputes Act authorizes members to workers to be a member of a union and to engage in union activities, basically. So on our review, we believe it may very well be this provision may be contrary to that legislation.
Chairman, you know I won't complain about that deletion.
Yes. So, do we agree, members, for clause 107 to be deleted? Yes. Point number 3, paragraph 3, Minister.
I believe, Minister, that a decision was taken for 108 to be deleted by this committee.
Yes, clause 4. Paragraph 4, that is.
The ministry recommends that clauses 109 and 110 are to be deleted. We believe, well, the policy or the revised policy is that the remedy ought to be through the tribunal and not through the criminal court.
Yes.
I'm very happy that the ministry has taken this enlightened position.
So we agree. Very well. Paragraph 5, Minister.
Minister, paragraph 5 speaks to clause 111, and we are recommending that subsections 1 and 2 are to be deleted.
Well, that's
Yes, Member Brown. Do we, before you proceed, we agree, members?
yes for me.
111, 1 and 2. Paragraph 6, Ministry.
Clause 111.3 is to be deleted, and we recommend that it is replaced with provisions that specify that the tribunal can make any one or more of the following awards as appropriate if it determines that the person conducting the business or undertaking acted in breach of section 103. 1, that the acts complained of cease with immediate effect or be reversed. 2, that the person conducting the business or undertaking pay within a specified period compensation that the tribunal considers appropriate. And 3, that the worker be reinstated in his former position, or if that position is not available, re-engage in a similar position.
Members?
Just a clarification, Chair. Compensation. What you have in mind?
So let us say that it is a breach of the contract of engagement, and the independent contractor cannot, well, the PCBU, when the tribunal deliberated on the matter, they do not believe that it is prudent to actually reinstate or to cause the independent contractor to continue working, then the tribunal may believe that, having regard to the circumstances of the case, that compensation may be a better option than insisting that the independent contractor continues with the work.
Yes, Member Brown.
You're talking, therefore, in terms of wages, lost earning.
Or the cost of the contract, for example.
And sorry, Carl, just put.
Yes, Member Brown.
I've heard, and I don't always follow what eminent Queen's Counsel say, but I've heard Queen's Counsel argue that the common law approach to compensation is nullified because the LRIDA gives rights to workers to be compensated, and you can't argue the common law approach to compensation. Where do we stand? Where does the ministry stand in respect to that? Here. I understand lawyers have to be like Trump. They just say things for the moment. But since answer some lawyers, let me refrain. Some lawyers. So let me raise it because answered is often part of assistance to courts and tribunal. So I'd like to get a sense from the ministry what you're thinking. Does the fact that we put this in statute eliminate the common law approach to compensation?
Do you have a response, Minister? The committee member.
I'm just seeking clarity, Chair, in terms of specified period of compensation. I'm just waiting for the Sis Michael to
Her undivided attention.
No,
Yes,
maybe she was seeking clarity too.
Oh, very well.
For a contractor, subcontractor, take a case where there's a contract for service for a specified period. So, is it understood that that compensation may take the gamut of that specified period in this case?
I think it's all dependent on the circumstances of the case. I believe that the tribunal would certainly have to take into consideration the portion of the contract that would have already been performed in arriving at how much compensation is to be made, to be awarded. Certainly it could not, to my mind, it would not be all of the value of that contract, but they would have to take into consideration whether or not how much of the contract has been performed and how much has already been paid before determining how much to award for compensation.
Why not all the value of the contract if the breach occurs very early in the contract? You're not saying that you can't get all, but you must take into account the duration and all of that. Is that what you're saying?
Yes, that's what I'm saying. I'm saying that what I'm saying is that all of the circumstances would have to be taken into consideration. How much has already been expended and paid, and the value of the work, for example, that is left to be done. Also, remember that the compensation would be basically to put the person in the position that they would have and so those are things that the tribunal would have had to take into consideration.
You are confirming first that the common law approach to compensation is the one that is intended under this legislation.
I would ask that I take further advice on that matter.
Yes, any comment from the legal teams? Mr. Simmons, yes.
All right, for my part, and I guess I'll wait to hear what the ministry has to say, I do not think that the common law approach can be used under this act. That's what I can.
I'd love to get an explanation as to why it can't be, because there's no statutory approach to compensation being advanced in it. And the mere fact that we pass certain rights by statute doesn't take away the common law. That's my understanding. So I don't know. So explain for us.
In my view, it can't be the common law approach because the IDT is not a court.
You mean?
It's not a court.
So let me ask you, when it says that it can be impeached on matters of law, it isn't to take into account the law of the land?
when it says that the IDT's decision can be impeached on matters of law, you're not really attacking the decision itself. You're attacking how the decision is made.
To stop a tribunal, because it's important to us. Is there a guideline, if not the common law approach? Because the tribunal may come to whatever compensation it wants. But what is the guideline that an advocate before the tribunal would argue that should determine compensation? Is there some new thing that we're creating, if not the common law?
With the IDT as it currently stands, it has its own method for determining compensation. I don't believe any case, the IDT certainly cannot establish precedent in the way a court can. So I do believe you have had complaints over time saying that the IDT is not very consistent in how it makes its award. And I do believe the court has said that the IDT is free to make its award as it sees fit. The only way the court intervenes is if the way they go about making the award is done incorrectly. For example, if they take into account considerations which they shouldn't have, or maybe there are considerations which they ought to have taken into account, or maybe they simply didn't have jurisdiction to hear the matter.
Chairman,
Yes,
if I'm understanding Mr. Simmons clearly, it points to our industrial relations framework being in a very at a very dark point in our administration, because the whole business of having a setup like that is that it introduces some certainty in our practice of industrial relations. And if you're saying that as it is presently structured, the tribunal has free range, as it were, to do what it wants, aside from having the possibility of being impugned on the basis that it considers something which is irrational or otherwise, and those little things. But somehow, I just think that we need to do it such that it introduces a greater level of certainty. It cannot be that the tribunal is now can go anywhere, as it were, aside from having the possibility. We need to introduce a greater level of certainty so that the businessman, Mr. X, who is coming out of North America or Europe, knows exactly what he has to deal with, and is not just left to the women fancy of three learned gentlemen who are not guided by the law at all. It's not a court and all that. But so I'd ask us to consider whether or not the framework within which we operate lends itself to certainty and an expression of where we really want to be.
The only response I have to that is that what I do know the IDT considers are whether or not the rules of natural justice have been observed, or whether or not the labor code has been followed. But it certainly does not establish precedent in the way a court does, because it's not a court.
Yes, I take your point, and it disturbs me that I have seen 20 or 25 cases over the last year where they, particularly these fixed-term contracts, where the tribunal, as it were, has thrown out a clause which says the parties have the right to determine the contract. Say, oh, okay, I can give you notice 6 months or 3 months. It's just thrown that through the window. It has the power to do that, right? And that's what it has done. So here we have two parties who are negotiating pretty much at the same position. Because one has to look back. Before the amendment came, I think it's 2011 or thereabouts, or somewhere there. Yeah. This regime was not intended to be for the benefit of non-unionized workers. And we've introduced this now, and everybody can go there. And so we are left with this uncertainty, as it were. And I feel very uncomfortable, and I've seen a number of businessmen. And this is what, I don't want anybody misunderstanding me and thinking that I'm on the side of any one party. But I would want to see a greater level of certainty, so that where the tribunal is making a decision, we can, with some level of certainty, wherever we're coming from, whether if we're acting for the worker or we're acting for the employer, that we know that when we go there, this is likely to be the result. Other than that, it flies in the face of established legal principles, and that we have a tribunal which ought to be guided by something, and you say, well, it doesn't have any precedent. It can't set a precedent. So what should guide me as the employer or the worker, for that matter, that in the unlikely event that I have an issue, that I can't go there knowing what this tribunal is likely to. And particularly as it relates to these fixed term contracts that we have, where it has pretty much thrown them through the window.
I hear Member Campbell's concern, but I don't think this committee has the remit to decide how the IDT at this present time is constructed.
Yes.
As for the fixed term contracts, my only comment on that is that I believe I tend to agree with the IDT that it need not have notice of any notice on any contract in how it makes this decision. The notice on that contract and whether or not it was observed is really the purview of a court, not the IDT. And you don't want to conflate the principles that govern termination under a contract necessarily with how matters are decided before the IDT. It's what takes place before the court and the IDT are actually two different avenues of law, for the want of a better phrase.
Chairman, I raised the issue about compensation
Yes.
in this bill.
Yes.
Because it's important for us to get a sense and for the tribunal to be guided by the thinking of the parliament as to what compensation can be. And Mr. Simmons, you're right. The tribunal doesn't set precedents. But this tribunal is guided by precedents. And this is why panel has spent so much of his time giving guidance to the tribunal. That is why the Court of Appeal has spent so much time giving guidance to the tribunal. That's why the Privy Council has spent so much time giving guidance to the tribunal. For example, at 6.3 here, Senator Gale was just raising, the issue come up about similar jobs. So that for us, if it's not the common law principle of compensation, that the tribunal may be guided by, can't tell them what to do, but they must have regard for that. Because if they fail, there could be consequence. Is what else? Because there's no statutory thing. I remember a case, I'm trying to remember the name of the case, in which, it's one of the early cases in which panel said that all the LRI did was to give some new rights, but it never changed the common law and the other elements of it. And that is why I'm asking if when you come to look at be it unfair dismissal, be it OSHA breach, is there any standard that the tribunal may be guided by? Yes, it has the power to do its own thing, and the law says you may make whatever award you want to make. But I've seen the Court of Appeal strike down award because it says a man was on layoff and you shouldn't offer him payment for that. So these are issues that must exercise our minds. And if we say to the tribunal you can compensate, at least tell them you're not restricted from the common law and there's no statutory direction about compensation. I don't think the common law stands in such circumstances. And it's for the tribunal to decide in their own judgment how much they want to award or what they want to award, but they can't ignore the common law.
If I may, Mr. Chair, I don't think, though, that what the ministry is attempting to do is to set any new standard in the case of OSH, because all of the matters that they referred to in their proposal are, in fact, matters that would come under industrial dispute, dismissing or suspending or disciplining a worker.
Yes.
So I don't think there's any need for concern about this statute, the OSH bill, setting any new standard, because as it is at present, the IDT, I think, would be competent to deal with these matters as they have been doing over the years.
Very well, Mr. Simmons. Ms. Michael?
I think Mr. Simmons just said what I was about to say, Minister. We do not intend in this bill to set any form of standards, new standards, as it relates to the tribunal. Certainly, we are aware that there are ongoing debates as it relates to the compensation, and I think that is one that will have to be addressed in a totally different setting. But I don't believe that we would be able to address that particular issue here. And the reason for this is, as it relates to the existing workers that falls under the LRID, there are already awards that are being made by the tribunal, and those, to my mind, the particular awards are not yet, the courts have not yet indicated, or they have not said that they have any such jurisdiction over the awards that are made. The matters that go before the tribunal are generally on a basis of law. So I believe that we would have to do some work as it relates to the compensation issues and whether or not there are standards or guidance criteria to guide the tribunal as to standards, as to the awards to be made, but I do not think that this is the appropriate forum.
Yeah. Very well.
Chairman, I don't necessarily agree. I understand what you're saying. In the British approach to the tribunal, they set a statutory the regime for compensation. Can't be more than X, such and such, deductions. The British have said that. So that we have not set a statutory regime here, is what I'm saying. And I don't have a problem with that. I agree there should be no statutory limitation on what the tribunal can do. And there are at least two cases that challenge the tribunal's amount. There's the private power case, and there's the Montego Bay Marina case, in which the court has said, it's your call, it's your discretion. I raise the point because I've noticed a novel, not coronavirus, but almost as dangerous as that, a line which says, you can't, in coming to compensation, have regard for common law principles. And I want to be clear that we are setting no new standards in this legislation, and therefore, what has operate now, the discretion of the tribunal, is what will hold, having regard for whatever submissions are made before them. And I do this conscious of the Marilyn Hamilton UGI case. I'm eagerly awaiting the Court of Appeal decision, but that has set a nice little precedent for compensation, Mr. Simmons.
So I can repeat the name for me, please? I didn't get the name of the...
In Hamilton, UGI, that has spent so much time in the court system.
So you're using this medium, Member Brown, to highlight the need to fast track that?
Well, I certainly hope the Chief Justice will hear us and try and get the Court of Appeal to decide on that soon. But the key thing for me is that we want to be clear that when we set this about compensation, it is obvious that there is no new standard being set other than that which exists now. So all I want to be satisfied on.
On that note, we can move to number 7.
It is our recommendation that clause 111.4 is deleted.
Any comments, members?
No problem with that being deleted.
Number 8.
No problem with.
The ministry is of a view that clause 111.5 is to be retained, as we wish for it to be expressly stated that what we are doing, that this legislation or nothing here is to be limiting any of the powers of the tribunal under the LRIDA or any other enactment.
I concur in keeping it.
Okay. So we agree that 111.5 be retained.
And 111.4 to be deleted, sir.
111.4 for his mic is now off. Yes, 111.4. The proposal, which I believe was, is for it to be deleted. Agreed? 111.6 to be deleted.
Agree.
Paragraph 10, Minister.
Clause 112 is to be deleted, Minister.
Yes.
If I may interject, I'm not clear as to why 111.5 is being retained.
Minister?
Minister, we believe that it is not the intention that the provisions are to be construed as limiting the existing provisions under the LRIDA, or if there are any other enactments, those enactments.
Members, any comment? Legal reform, is it that you believe that this provision is to be excluded from the bill?
I'm just not. Well, I did say earlier that I'm a bit confused as to. Right, let me rephrase. I believe the holding. Is the procedure under this act any different from what it currently obtains under the IDT? And if not, why do you think that there's a possibility that this act will limit the powers of the IDT under the Labor Relations and Industrial Disputes Act?
Strike me that out an abundance of caution. It's the equivalent of a saving clause that is being advanced here.
No, but are you saying then that there are going to be two ways in which you can deal with these matters under the IDT, or one way? Because if there's only one way to deal with the matter under the IDT, then you don't need this savings clause, so to speak.
Do you have any comment, Minister?
Minister, when the clause first went in, we were seeking to operate two regime. We were seeking to operate a single regime where everything would go to the OSH division of the tribunal, which would include the employees. So if employees who would have had a right under the LRIDA, if they had OSH complaints, then they would have been treated under the OSH division and under this bill. Since that time, we've made some amendments, and we have in fact kept the regime as it relates to the employees under the LRID. So we are now operating basically two regimes, one with the LRID and one with the wider definition of workers for those who do not fall within that regime. So we were, I guess I'm coming around to Mr. Simmons' view that we may not need this provision. However, I would like to have the opportunity to consider it a little more.
I'm fine with that.
Yes.
I'm fine with that approach, because we have to make it very clear in terms of the boundaries that we are operating under.
Yes. So, Mr. Simmons, the ministry will get back to the committee on the status of clause 115. Clause 112, paragraph 10. Ministry, you were taking us through that.
Yes, Minister, we are recommending that clause 112 is to be deleted.
And that fits into 2E that we have been discussing, that we were discussing earlier. And in light of that, you don't need 112. Sorry?
Yes, that is correct. This is covered under 2E above.
Very well. So we agree, members? Good.
Yes.
Paragraph 11.
11.
Minister, we are recommending.
Just to be clear, all of 112 goes.
Yes, all of 112. As it relates to paragraph 11, we're recommending that clause 113(1), subsection 1, subsection 2, and subsection 3 are to be deleted. Our rationale is that it is not necessary because we have the dual, yes. So we do not want to have that. The purpose was to prevent them from benefiting twice, but with this regime, I believe that we have cured that defect.
So clause 113, 1 to 3. Members?
Having deleted 109, just to talk the language of the thing, having deleted 109 criminal proceedings, we no longer need this because we're going to have only one approach, which is through the tribunal. That's my understanding.
Very well. Approved. Paragraph 12.
We are recommending an amendment to.
Member Gill? Yes. Oh, proceed.
We're recommending an amendment to clause 113, subsection 4, that the word conduct be replaced with the word complaint. This is in the preamble.
Yeah, members, any comments?
My comment with this particular provision in relating to orders. So A specified the retrospective effect from such date being earlier than the date of conduct. So it's speaking to how far back the award can be. Specify the date from which it shall become effect, and for it to be final and conclusive. But if I can recall, in the LRIDA, it specified a time frame in which the tribunal may make the award. Now, is there a suggestion in this particular area to identify the time frame in which the tribunal may make an award? Was that contemplated?
Yes, we considered, and what we're trying to do is to learn from our mistakes. We have a 21 days in the LRIDA within which the tribunal is to make an award.
Which incidentally it's not practiced.
Yes. However, based on the volume of work that goes to the tribunal, we have seen where it is impracticable for the tribunal to actually hand down awards within 21 days. And so we would not want to put something in this legislation that already precedent has shown, or, well, it's not precedent, but we have already experienced that it is highly likely that we would not be able to meet that time frame.
Chair, the concern I have with this is that, yes, we agree that we would have opened up a plethora of issues to be submitted before an IDT that does not have the capacity to treat with it. And so it becomes a capacity issue. But we also have to take into consideration the question of setting standards. Now, if the tribunal cannot make an award within the defined period as stipulated by that piece of legislation, then I'm suggesting that at least the tribunal must be able to say something to the parties involved in the dispute and not have the parties involved in the dispute awaiting the outcome of an award. It's all good and well when we establish time frames that are being breached, but they are being breached without even hearing anything from the powers that be that should make the award. And I'm contending, Chair, that that is not good enough.
Yes, Ms. Michael.
If I may direct you to paragraph 14, I don't know if that will assist in any way, but we are actually seeking to insert provisions for the tribunal to make rules to expedite the proceedings relating to the complaints.
Paragraph 14 of the ministry's document. Would that satisfy you, member?
Well, I don't know what those rules are, sir, or what they will be. But if it's a principal approach, I'd be guided as to what those rules would look like.
Very well.
Chairman, the provisions at 113.4 are provisions that are now contained in the Labor Relations and Industrial Dispute Act. It's just lifted from there. Second thing is that it's about capacity, as my friend Senator Gale just pointed out. If you have one tribunal there to deal with ash matters, one panel, you may have them sitting doing nothing. But if there's a flood of cases, they're tied up. And invariably it's the same set of people who traverse the halls of Ellismere Road now, who will be dealing with the ash matters. So by virtue of scheduling and so forth, the desire to get ash matters dealt with quickly, we may not achieve it. I mean, was it Justice panel who said the quid pro quo of ending strike early. A long time before Trump quid pro quo was used in these cases. He said, or was it Cook, who said that the purpose of ending these things, I think it's panel in the Palace case, that the purpose of ending the strikes and ghost laws and so quickly is that you'll get a quick judgment. That hasn't been the case. What will the ministry do to ensure quick judgment? Are you going to put in rules which says you can co-op panels? You don't have to have a permanent panel, but you can co-op panel depending on the workload. I think the current LRID allows for a maximum number of panels, although you can have special divisions. But I believe the ruling is that these special divisions can only come into place if certain things happen. So is there going to be a regime of saying special divisions depending on the workload and so forth, so that we could get what Senator Gale is asking for, expedition in addressing these ash matters? Otherwise, we may end up having an ash matter at the tribunal for 2-3 years.
Legal department, any comments? Yes, Mr. Simmons.
Not at this point, Chair.
Okay, very well.
Yeah,
yes.
Particularly, Mr. Simmons, you see this paragraph C, which amounts to an ouster of the jurisdiction of the court. Is that your view?
No, that's not my view.
Because shall be final and conclusive, and no proceedings shall be brought in any court to impeach the validity thereof. And this is a very point, on a point of law. So if the tribunal were to make an excessive award, is that, and you're attempting to get it reduced, would that be, could you do it?
If you can bring it within...
No, because there's no precedent. The tribunal can do whatever it wants. Can make any award.
I wouldn't put it that...
No, but it has no... It's not...
I wouldn't put it that IDT can do whatever it wants. But I do think...
What guides it? It's not a precedent. What guides it?
What guides it is, as I said before, the labor code and whether or not...
So it is law?
The labor code is as... Labor code is as can be. Based on the few judgments that I've read coming to IDT, they do tend to follow the labor code and the principles of natural justice as their guide. But in terms of quantum, that is within their discretion. If it is you can bring the quantum within a breach of the law, then you can then impeach that award on those grounds.
The Parliament has set up these specialized tribunals to look at facts. They are the master of the facts, just like a jury. The issue is if they, in mastering the facts, create a breach of some of those 1,400 odd common law and anyone more recent than those. So that's what these tribunals are being set up as fact finders, and their finding of facts are not going to be altered by any court. And the courts have accepted that, right? And so it's not ousting the court, it is giving power to the people closer to the workplace.
All right, we are back on paragraph 12, where the minister is seeking a substitution in the preamble, that the word conduct be...
I agree with that, Chairman. That's kind of clear cut.
Yes. Paragraph 13, it's for the entire clause 114 to be deleted.
follows, if we move 109, that you don't have, there's only one regime now, no criminal, but just the civil through the tribunal, then we don't need 114.
Agree, members? Very well. Paragraph 14, Ministry.
That provision be made for the IDT to make rules to expedite proceedings relating to complaints emanating from this part. So we would be, well, we wanted for, I guess we'll be talking to CTC to come up with something, because we would need for at least the IDT to have some structure, something to guide them, and for them to make some rules as to how they intend to expedite the matter.
Chairman, like all tribunal, the law setting up the IDT says that it may establish its own procedure. Just that those procedures are not in writing. No, I don't know if that's what you intend, because they have their method of doing these things, and the parties who appear before them regularly understand these things. So I can't be for the tribunal to be setting up these rules. It may be that the ministry, because in the current LRIDA, that's where you find the 21 days that Senator Gale mentioned. So if we want to set those new rules to deal with this for expedition of the hush matters, then we should do so by way of regulations, code, or whatever. But I don't think you should leave it to the IDT to set. They already have their rules. I can tell you, report come to them, they write you and say, well, we get a report, send us briefs in 9 days, and usually them extend that 9 days to eternity if you don't send the brief quickly. They have the power to hear matters ex parte. So there are rules there already. Right? So this doesn't help us in any way unless we are going to make rules for them.
Mrs. Seeley Brown, you're making a comment. Your mic. Yes, let us hear.
Member Brown, because it's a new area, I don't see any harm in us for avoidance of doubt, including a general provision to say that they may make rules, even though, as you're saying, they may have, but it's a new area, and just out of an abundance of caution.
I hear you, but there is a clause there which says they may establish their own procedure. Yeah, already. In the LRIDA, no. There is such a clause, is what I'm saying.
Yes.
General, don't throw us back on the general.
Yes. Mr. Simmons, you had a comment?
I was only agreeing with Member Brown that the LRIDA does give the IDT that the power to regulate its own procedure. The only thing going through my mind is whether or not they can actually do anything to expedite the matters that are appearing before it at this time.
Yes. Yes, Mrs. Patrick Gordon.
Just a correction for the record. The IDT procedure is in writing. It is in writing. I've seen it.
Oh, she is making the point that the procedures of the IDT is in writing. I think it's maybe flowing from a comment you made, Member Brown.
Where? Where in writing are they?
I have seen it. I don't know how well it's disseminated, but it is in writing, member. I understand it has been used against them as well in a recent.
I have never, in my almost entire period at LRID, to know, I've never seen those in writing. I know that there's a document that UNTA did, which was a guide for people. but the tribunal has never shared. I mean, I've been there where, sorry, Les, but lawyers come and asking that they should be allowed to go second in dismissal case and all of that. That's one of the rules the tribunal have, which says that dismissals, the employer must, the burden of proof is on the employer. But that's not written anywhere that I am aware of. And if you go to the tribunal and ask them, tell us the guidelines you have, them say, oh, Mr. Hunter, they write a book many years ago. So a lot of the tribunal is informal. Maybe after 75 to now, 45 years, maybe it's time to formalize a lot of things there. That's part of the job of the ministry to look at that. But as I said, paragraph 14 in this document, Chairman, doesn't add anything to what exists.
So the ministry will revert. No, the ministry will revert to the committee on paragraph 14. Paragraph 14 of this document. Yes, because what has been put forward by the members is that it is not necessary by virtue of written provisions of the LRID. So the ministry will come back. So we would have completed our work on the, save and accept the areas that the ministry is to come back to this committee on. We would have completed the work in part 6, so we now move on to part 7. But I believe that this is a convenient time. Unfortunately, members, I'm told that no lunch is prepared downstairs, so that may impact the, no food is here. So, yes, absolutely not. As much as I'd want to, you. Yes, so let me hear from you. I believe that by virtue of the situation involving downstairs, we may want to break for the day. Yes. Members, yes.
Because we have no date set.
Well,
for
a date was we had set Thursdays tentatively, but I'm now advised, and you and probably Member Brown can confirm that you will have a Senate sitting.
Yes, we will have a sitting of the Senate.
Oh, well, I'm up here now, Member Cuthbert, and you know, you have not made a premature departure today. So we'll come back on Monday of next week, and we'll do.
Remember, those are not dates that were set. So
Oh.
you're proposing now?
Well, that's exactly it. We're proposing. I thought by this we will have established that the Mondays are, yes, OSHA days.
No, you see, I'm a creature of.
And we've been doing this on Monday.
No, we've been doing it on scheduled dates. Outside of Mondays, we started out with Mondays, and then I don't want to say the chairman went off on a holiday because work was done.
Yeah.
So is it that we're going back to Mondays now? Because I have to know in terms of.
We are going back. In fact, I'm happy you raised it, Member Gail, because I think we should just book our schedule for the period of February. Where we are in the parliamentary period, I believe we have to do as is necessary to complete this part of the process. Already we have exhausted 13 months or thereabout. So I believe that twice a week meetings have become necessary. In fact, more once your schedule can accommodate it. So we were moving with our Mondays and Thursdays. We have done well in the month of January. I'm suggesting that we continue using those 2 days per week for the month of February. Yes, we will. I'm told that Monday, by virtue of the Parliament on the Tuesday of next week, we will have to do a shortened, which will go to 1 o'clock on Monday. On Monday of next week, the 10th.
The House will be prorogued, so they would need
The
to
10th,
get the
yes.
chamber ready for House.
So we will do our first sitting. On Thursday of next week, we will go yeah, so we can meet at 2. On Thursday of next week, we meet at 2. Yes. Yes, the BOJ Act. Yes. Next week, Thursday.
Next, the 13th. Really?
Okay. Okay, so we will.
That's what I will double check.
Yes, so the clerk will double check to see whether next week, Thursday morning, is available. Once it is, members, you will be notified via an email. But we are proceeding with our Mondays and Thursdays for the entire month of February. Yes.
Mr. Chair.
Yes,
Mr. We're setting next week Monday at 10 and next week Thursday at 2.
At 2, and if our Thursday time is going to be adjusted until 10, you will be notified by an email.
And then the other Mondays and Thursdays.
Yes. Member Gill.
No, you see, you have to understand the logistics, you know. So if we're going to set it at 2, we set it at 2. But some of us may want to sneak in a meeting elsewhere at 10 from today, if possible. So if we're setting it at 2, we set it at 2.
All right.
No. I'm talking about the Thursday.
How long is that going to take?
All
right. The clerk is going to confirm whether 10 is available on because I get the feeling members would rather have in the early morning sitting and the afternoon is.
No, the challenge I was having is to set a time and then the time is going to be changed to another time in the day when that time could have been used for something else.
Okay, very well. Well, the clerk is going to confirm, so within a minute, momentarily, we will have a confirmation. Yes.
Chairman, while the clerk is confirming, I note that there's an accident on Friday in the New Kingston area where a worker, I assume under this definition, suffered electrocution. And I don't know if that has been reported to the ministry. And maybe not today, if you could tell us whether this legislation could in any way have affected, prevented such an accident from taking place. Dumfries, setting up a scaffold.
Yes, to answer your question, we are aware of that accident and we have started to make arrangements this morning before we came to Parliament to have an officer dispatched to do an investigation. So this legislation, although we have the Factories Act that covers those type of activities, it was construction related. Actually renovation, I was told that they were painting the building. So just as all coverage is under the Factories Act, there will be coverage under the new legislation.
You're saying that that accident, the ministry, under the Factories Act of 1943, you are able to investigate and impact that.
Yes.
And that this new legislation would reinforce
Yes.
the 1943 provisions.
Well, it will, yes, give us coverage.
I've been advised that our 10 a.m. on Thursday of next week is unavailable, so we meet at 2 p.m. So for next week, Thursday only, our meeting will commence at 2. Thereafter, we revert to Thursdays at 10 a.m.
Chairman, just separate from the date.
Yes.
This legislation which you were working so hard to put
Yes.
through hasn't been getting the coverage. I mean, nobody like when I tweet. Some people don't like when I tweet. But I tweet out the fact that we're meeting and people really didn't know that the committee have been meeting and addressing these issues. And maybe your ministry would find a way to connect Friday to say you're investigating and that the new legislation being done, it's covered under the old legislation, and the new legislation would also impact issues like that. So you, in a way, your public relations people could address the importance of this legislation that we're working hard on.
Suggestion duly noted, Member Brown. Do we have any other business? May we have a motion for adjournment?
So move.
This meeting is now adjourned until Monday, February 10th at 10 a.m.